Hello guys, my name is Amit Sani and I welcome you in this daily UPSC MCQ series. On a daily basis, we are discussing some questions from a static portion, some questions from the current affair based issues. And current affair based issues, they are also having a background of static portion. So in-depth analysis we are doing for certain topics. So these isolated topics, they are perfect in a sense. So it's an important addition. Please do not miss any of the lesson. On a daily basis, 5 to 10 questions are coming. So they are covering a very important portion there. So 28th of June it is, and let's start the lesson of today. I hope you people are watching all the lessons which were there in the past, and affordable courses by StudyIQ, they are available. You can call on the numbers provided by the StudyIQ channel, and the description is there below the video. So link is also given there, and you can chat on the website also, and these are the numbers there you can call. PDF you will get here on this Facebook group. The Telegram's link is also given there, and you can follow me on Instagram also. I will provide the link, and this is the particular channel on Telegram where I upload the PDF, and the StudyIQ's channel of Telegram for these PDFs. You all know about that. Question 1. It is from Polity. It is regarding the Rpa Act, and it is asking about that a person can contest from two constituencies. Many times we have seen this example, like in the case of Rahul Gandhi, in the case of Mr. Modi, and many other important leaders, and they fill this form from two constituencies, and maximum two constituencies are allowed in all the elections, like Lok Sabha, the important Aam Chunavs, or the Lok Sabha elections. Rajya Sabha elections also, there this phenomena we see, and in the state legislative assembly also, Vidhan Sabha elections also, where this thing is allowed, and in some states there are legislative councils, so for their elections also this thing is allowed. So maximum two constituencies anybody can fill the form from, and if that person wins from both the places, then he or she has to vacate one seat of their choice. So that's the case, and it's a simple question. This provision is there in the Representation of People's Act of 1951. So D would be the answer here. 1, 2, and 3, 4. All are correct. Section 33(7) is there in the Rpa Act of 1951, and it's a very specific act. You must know all the facts given in this particular act, because it is separately mentioned in the prelims syllabus there by UPSC. So maximum of two constituencies, not more than that. CIC, established by the Right to Information Act of 2005 by a gazette notification. They established this, so it's not a constitutional body. It was established with the RTI Act. So they may ask you about that. It's a non-constitutional body, but one of the most important bodies. You see, when this RTI came, after that the average person in this country that became very much capable to seek any kind of information from the public offices, and it's a mandatory provision. They have to provide the information. Some specific conditions are attached there, but normally they have to give the information within a stipulated time, and there is a provision of penalty also if that person does not provide the information in time, and officials are appointed for that particular duty. So the CIC, in a sense, if you talk about the salaries, allowances, and other service conditions, then they are equal to Central Election Commissioner, but not in any other sense. Regarding the removal and all, it is not equal to CEC, because CEC's removal is very difficult. It is like the Supreme Court judge's removal. It's a kind of an impeachment process, and there in both the houses absolute plus special majority would be needed, but it is not needed in the case of CIC. So CIC is important. One CIC plus 10 information commissioners would be there, and they would be appointed by the president and removed again by the president. But you see, there is a certain process, and appointed and removed by president does not mean that president has any kind of discretion here. It is not the decision of the president. President just say this thing where the recommendation is coming from the prime minister, and how, on what basis. There is a selection committee chaired by Prime Minister of India. So one Prime Minister of India plus one appointed cabinet minister plus one leader of opposition. These three people would be there in the committee, selection committee, and that would recommend the name, and the name would be forwarded to the President of India, and he would appoint a person as a CIC. So for a long period of time, CIC was not appointed in the last government's tenure. Now it became a huge issue. So a very important office, and it gave many informations, and after that information only many corruption cases were in the public domain. So that was the case. So first is correct, second is also correct, he is not eligible for the reappointment. Third is not correct because it is asking that salary allowances and other service conditions are similar to election commissioner. No, it is chief election commissioner. There is a difference between the CEC and the ECs. There is a huge difference in some conditions, like the appointment and the removal. You see, the removal of CEC is very difficult because as I told you, special plus absolute majorities would be needed in both the houses, but not in the case of election commissioners. Okay, so election commissioners can be removed anytime, and CIC also can be removed at any time, and the conditions are there, like some grounds are mentioned, and the matter would be referred to Supreme Court by the President of India. If the Supreme Court finds that the CIC is doing something wrong according to all the provisions, then that can be removed after the suggestion is forwarded to the President of India. So President of India can remove CIC after the discussion to the Supreme Court. Okay, so 1 and 2 would be the answer here. 3 is wrong. You can see, if he is adjudged an insolvent, convicted of an offence where moral turpitude is involved, and the other important things like paid employment, if he acquires some kind of job or something like that, infirmity of mind and body, and any other financial interest if he or she develops, and proved misbehavior and incapacity. On all these grounds, President would refer this matter to Supreme Court, and Supreme Court would do an inquiry into that matter. If it finds that the allegations are correct, then it would suggest, as the inquiry says, to the President of India, and the President of India would remove that person. So this is the provision. There is no provision of majorities in the houses or something like that, as in the case of Chief Election Commissioner. Okay, so that is the case, and not eligible for the reappointment. Okay, and 65 years the maximum age, and a term of 5 years, whichever completes earlier. So that's the case, and you see, it is equal for Chief Election Information Commissioner and Information Commissioner. Both CIC and ICs both will serve till 65 years of age. But it is not always the case in some other bodies like the Supreme Court judges and the Chief Justice of India, and in the case of other bodies, there is a difference between the chief and the other judges or the commissioners. But here in CIC and IC's case, this is equal. They will serve for 5 years and 65 years. So these things are very much complicated to remember. So I am giving you some hints that this thing is very much important, and here you may fail. So that's why please listen carefully. There may be some confusions, but you have to listen very carefully in the polity, and that's why I say polity you must revise daily. Okay, and you see, this office comes under the Ministry of Personnel. That you need to remember. It has power of a civil code. That is also very much important, and all these evidences and all, it can call them. So this is the condition here, and equal to Chief Election Commissioners in the case of salaries and allowances and other service conditions. They cannot be changed after the appointment. Next question is regarding the Article 323. It is talking about the tribunals, and there are two important sections, 323A and B. A is for administrative tribunals. ATs, tribunals are specific type of courts only, and for the administrative matters like the civil service conditions and all, and their conduct of the important central government employees and all. So for that, administrative tribunals are there. And for other important matters, if there are tribunals, then they will be established under 323B. So you must remember some things here, that administrative tribunals can only be established by Parliament. So this power is given to Parliament, that by the process of lawmaking, it will bring laws and it will establish the administrative tribunals. So first is wrong, because it is the only power of Parliament. For 23A means the administrative tribunals, and the tribunals for other matters, they can also be established by state government apart from Parliament. So both the legislatures are allowed there. So this is also wrong. Third is correct, because in Article 323A regarding administrative tribunals, there is no provision of hierarchy, but the provision of hierarchy is there for 323B. Okay, so 3 is correct here, and B would be the answer here. You can see 1 and 2 are incorrect, and there is hierarchy in other tribunals, not in the administrative tribunals. And 323A and B, these are given here. You must remember this picture always. Regarding A, all the provisions I'm mentioning here on many websites on the internet, these are given there. As it says that not a specific article for administrative tribunals. You see, it just says that Article 323A says that they would be established by Parliament. But there is a process, and by law, Parliament can establish them. Not just with the notification, by law, it has to establish them. So that's the case, and all the provisions you can read in the PDF. Next question is regarding the Rpa Act of 1951 again. Some grounds for the election offences, and if they are election offences, then election can be cancelled. What are the grounds? First ground, exit polls. That is a ground, because exit polls are not allowed. Exit polls, what are the exit polls? When people go to votes and they exercise their vote and they come out of the polling area, then their opinions which are taken, these are subjected to the exit polls, the data which is made out of that particular interview. So those are exit polls, and these are not allowed during the election process, any of the phases which are going on. So till the last phase is not completed, after that exit polls are allowed. Before that they are not allowed. Okay, in any of the phase they are not allowed. Only the opinion polls are allowed, because opinion polls are just opinions. But there are questions regarding the opinion polls also. Many of the experts and all, they are saying that these news channels, they are trying to manipulate people's mind a lot with opinion polls, because opinion polls are allowed and they will present the data in a way as the real results are coming. So opinion polls are allowed. You must remember, 3 is not an offense, but first is offense. Okay, and exit polls, you cannot say that exit polls are never allowed. They are allowed after the polls, but the last phase of the polls, when it is completed, then the exit polls are allowed, not before that. As we saw, Lok Sabha election completed in 7 phases. So after the completion of 7th phase, the exit polls were allowed. Next, promoting enmity on the ground of language, that is the offense. And booth capturing again is a simple thing, that is a clear offense. So 1, 2, 4 is the answer here. D is the answer. Next question regarding DNA technology. DNAs are very specific. They can give any kind of information regarding you. They will tell you what kind of eyes you will have, what kind of hairs you will have, what kind of body you have, and what kind of development there can be out of that information. Maybe in the future they may develop a particular human being also. We are not sure, because anything can happen. And DNA information is the basic information, genetic information regarding humans. So anything, it has no limits as the studies will go on, and as much technologies we are developing, anything is possible in the future regarding DNA data. So it's a very sensitive data, but it is introduced here, and the DNA identification is going on in some cases, but there is no specific law. So this bill was introduced in January also, but it lapsed. Now again they are introducing it. But the issues remain that in a country like India, where a lot of things are misused, a lot of laws are misused, loopholes are misused. So if the DNA data can be misused, it can be a horrible thing, and it can be a very, very objectionable and questionable thing. So we need to put some regulations there, and it's a very, very sensitive issue. And now say that only in criminal matters identity can be checked through DNA data. This is wrong, because there are civil cases also. IPC 1860 is also applicable here in some cases, and out of some consents, in some cases where punishment is more than 7 years, consents are not allowed and all. So there are categories for under trials and the suspected people and all. In all the cases, they need to find the identity. So for the clarification of identity, they are bringing these important provisions in the law. So not only in the criminal matters, in other matters also this can be applied. Next, it will establish a DNA regulatory board. That is perfectly correct. Second is correct. First is wrong. So B is the answer here. And it's a huge law, huge provisions are there. And if you are appearing in the mains examination, then you need to read all of them. It was introduced in 2018 August month and in Lok Sabha, and passed in Lok Sabha in January, but could not be passed in Rajya Sabha, and that's why it got lapsed. Next, again when the government came, they are reintroducing it. And you see, problems are of this kind that any government would not have any difficulty in these provisions which are given here, because it will support the authorities always. Authorities would be able to get any kind of data regarding any kind of person, and the data would be there in the DNA bank. DNA data boards are going to be there, so they can access anything. So it is always desired from the government, and if it is going to be a tyrannous government in the future, then this is the first choice for them, that they want all kinds of data. So that's why it can be a problematic thing in the future. So many regulations are needed and many questions needs to be answered here. And you can see DNA based forensic technologies are the core things here, and the identification is the main issue here. So that's why all the details are given in the PDF. You can read that. Maximum information I am giving you here, and it's a huge thing you can read about on the PRS website also, and many issues are there regarding that. Mains based, prelims based, and in the interview also they may ask you about that. It's a technology based issue, it's a modern issue, and it's a very important issue of legislation. Okay, so context is very important here. Okay, if I give you an example that if it is giving any information regarding your allergies, and due to allergies you may die, because if the allergen is there, then you may die if the allergen is not removed. And if somebody is getting that access to the data, and somebody knows that you have this kind of allergy, then that person may kill you also. And that would be a very easy way for him, because he or she would say that I didn't know about that thing, that person was having some kind of allergy, and because he or she knew about that, then he or she may kill any person. So this kind of sensitivities are involved here, and in the future these sensitivities will rise a lot. And regarding the regulatory board, there would be a regulatory board, there would be a national and regional data bank also, and this regulatory board would be chaired by the secretary in the Department of Biotechnology. Under this Department of Biotechnology, this would come. So that's the case. Next, the Space Activities Bill. This was also introduced 2 years back, but again they are introducing it, and it is for the commercial use, not the non-commercial use. This is wrong. Second, private entities are allowed in this. That's why you see the issue is huge, that in many sensitive areas, cases where private entities were not allowed, now government is allowing them everywhere. Whether we talk about defense, whether we talk about space, now they are allowing them, and things are going into private hands a lot these days, and this is also the same case. So this is again wrong, because non-governmental and private sectors would be given licenses here by the authorities. So that's the case. So D9 is the answer here, and you can read the points in the PDF. Non-transferable license would be there, provided by the central government to any person carrying out commercial space activities. So it is regarding the commercial activities, and authorization of the government through the Department of Space. You see, Department of Space comes directly under the PMO today. So that's the case. Okay, and till now it is the exclusive domain of the government, and again this would be for the commercial space activities. Okay, you see these details are there. Next, methane, CH4, carbon's valency is 4, so 4 hydrogen can be added to it. Okay, and it can be a biomarker. Why? Because microbes, when they digest any organic matter, then they produce methane. When oxygen is present in a very less amount, then carbon and hydrogen are there in the organic matter, then CH4 would be made, and it's an important constituent of the natural gas only, and it's an important fuel also. We all know about the natural gas. CH4 is there. CH4 is also produced in your body, in your digestive tract. It is also there in the cattles. Cattles release a lot of amount of methane. In paddy fields also, many bacteria are there who are producing these methane. So everywhere microbes are there. So microbes, if are present in some other planet also, then they can also release methane. So it was the case where was the suspicion on Mars planet, and the Curiosity rover by NASA is moving there, and it found some transient methane plumes there, and those plumes can be due to some biological activity by microbes, So it's not sure because that rover does not have that tool that can differentiate that whether it is coming out of some biological activity or some abiotic process, because abiotic process also can produce methane, because only chemicals are involved here, carbon and hydrogen, and it can be made with the abiotic process, chemical process also. So it cannot differentiate that. But now they are clear about that it was just a transient plume and it was not due to some kind of biological activity. So till now, no evidences of life on Mars. So anything which can give evidence, it can be a biomarker. So methane can be a biomarker in some case. That is a possibility. So second is wrong, third is correct, one is correct. 1 and 3 is the answer here, because it is made through abiotic process also. Okay, you can read everything. This is the NASA's Curiosity rover there. It is moving there since 2012. 7 years are gone and it is moving there on the rocky surface of Mars. And there is sample analysis tool there, SAM, and laser spectrometer on board Curiosity. Last week detected surprisingly high levels of gas methane there near the Gale crater. So that's the case. So thanks a lot, keep watching, and we will meet again. PDF, please go through it, and many questions we will revise again. Thanks a lot.